we've discussed a number of issues at the bench. As I've said, I need to review some authorities based on this dispute I didn't anticipate. We'll return here on the 10th to complete the litigation over this transcript. Otherwise, other rulings. First of all, the voir dire will begin on February 10. Hardship, I'll be, let's just say voir dire begins on the 10th, and order all counsel not to be engaged in any other matter. I will proceed on this with any or all counsel, but in order not to be engaged and to proceed on the 10th. Mr. Kieran?
Will we be able to get the completed jury questionnaires at least 10 days before we start the voir dire?
No, you will. They will on the 10th. They will commence. They'll fill out the questionnaires on the 10th. In other words, the 10th, 11th, 13th, and 14th. We'll have just an initial voir dire. The jurors will receive the questionnaires. They will fill them out. They'll be photocopied. The people have offered to do the duplication and share them with the court and with the defense. And then you will have 2 weeks to review those questionnaires. Then we'll begin the oral voir dire.
So that means, Your Honor, that, just so we're clear, then if that's the 10th that we're starting, then it would be 2 weeks from the 14th, or 2 weeks from the 10th?
From the 10th.
Okay, so that means that we would start real voir dire, for lack of a better term, on February 24th.
Yes.
Okay.
And we should have a jury by the end of that week. We will then commence evidence March 2. Additional rulings. As far as the people's motion under 356, the people have, it's anticipating what the defense might do. I will say that there's no particular evidence identified by this motion, but I will say that, and I think you'll agree that the people have stated the law correctly as to 356 evidence code.
We agree, Your Honor.
Also, there shall be no mention of polygraphs or offer to take polygraphs under 351 evidence code.
We understand the law, we understand the ruling. Our only issue, Your Honor, was that we had questions about whether it was an investigative technique, but we understand the limitations and will abide by the law of California.
Right.
On cross-examination, we had anticipated talking to the police about one of the people that was suspected of perhaps being responsible for Ms. Berman's death, having failed a polygraph, but we understand the constraints.
So you're not, there's not any mention of polygraphs under 351. Right. As far as questionnaires, you've cooperated to draft a questionnaire that you will supply to me immediately for review and approval. I understand you're working on stipulations and have agreed to nearly 20 stipulations. That's excellent. There will be a hearing on January 13th and offer proof as to testimony by Dr. Denbo.
And Dr. Altshuler.
And Dr. Altshuler.
And Your Honor, the other issue was the third-party culpability.
Right. I think I made it clear that that it's what the standards are for admission of third-party culpability. It came up in a different context. I've seen nothing that satisfies that. And there's no proffer of if there were, you would need to submit that in advance to me. You should have submitted it already for a motion in limine. I've not seen anything. You're aware of what the evidence might be. One can speculate about some of the evidence, but the evidence I've seen does not amount to anything that would be admissible under California law.
You know, this becomes important because Mr. Chesnoff just a moment ago mentioned Niall Brenner, and in essence, his intention to question detectives about Niall Brenner actually being the true killer in the case, etc. I want to make sure Mr. Chesnoff understands they have not met the standard under Hall for third-party culpability, presentation of evidence, for any named person in this case. They can always argue Bob Durst didn't do it. They can always argue somebody else did it. They cannot put on specific evidence that any other person did it unless and until, and the court has already said and put a deadline of today for submitting that motion. So that third-party culpability ship has sailed.
Okay,
Mr.
well,
Chesnoff?
I don't necessarily agree with Sale, Your Honor. The trial doesn't start until when the court just announced it.
Well, you know, this issue actually, I've ruled on this already, and that was within the context of handwriting. I think that you presented the issue pretty squarely, that was your theory for questions about handwriting. You wanted to present discredited testimony, basically, about testimony that did not satisfy Sargon about handwriting. I disallowed it, and I think I made it clear that you what I've seen does not satisfy People versus Hall, and so you'll need to give me a written offer of proof before I would allow something. I would have expected it already.
Wait, Your Honor,
Your Honor, if the court expected it already, we would apologize for not having presented it. But in consultation with Mr. Ray, he's informed me that the time for this particular issue under statute has not passed. And we understand the government's or the state's position, and we hear the court loud and clear about what you just said, and we will operate as we feel we need to on behalf of Mr. Durst.
So my concern, and I know you may have a different concern, Mr. Lewin, mine was only that it not be, we not be surprised here in the courtroom with
Your Honor, this is why it's important.
but with such a problem.
Made the ruling. I'll explain. So,
Your Honor, excuse me for a minute. Mr. Lewin stated the law, the courts admonished us. We understand the circumstance, and we'll deal with it appropriately.
Right, okay,
I
so
don't have
let me
to-
make it clear, there's been no showing of third-party culpability, it's excluded.
well, the problem, Your Honor, is
He
that,
just said it's excluded.
Dave, I didn't interrupt you, so let me finish. It is excluded, Your Honor, going forward, not that the defense has to file something giving an offer of proof. The court told them last time, and I made this very same argument, we have to set up our opening statement, we have to prepare our case. We cannot be sitting there having to figure out whether at the last minute the defense is gonna argue Niall Brenner's the killer, the mob did it, et cetera.
But the last time I checked, Your Honor, it's not our burden to prepare them for their opening.
So here, let's stop for a second. I can't, I'm not gonna stop any party from presenting their fifth motion for reconsideration, but after the first denial, it becomes increasingly futile.
Well,
So there's nothing, so I've excluded it. Am I gonna say you were ordered not to make an argument, and don't make an argument to the court, I ought to reconsider? No,
Well, no,
I'm not
Your
gonna
Honor,
do that.
You did tell them, Your Honor, at the last hearing, when I pointed it out, because if you remember, Your Honor, they argued third-party culpability without filing a motion. The court said, you need to file a motion. They said, Your Honor, we will have a motion filed by the next time we're in court. They didn't do it yet again. We're now 2 months from trial. And Your Honor, here's the problem.
It's excluded.
Thank you,
Okay,
Your Honor.
next.
Awesome.
I think that's the last on the list.
No, there was
one-
two last things.
Go ahead.
Number one, and you put on the record, we will be presenting the evidence from BECTEC, B-E-K-T-E-K. These are the individuals who authenticated all of the interviews with Mr. Durst, indicating that they were not edited. If the defense at any point in time comes to us and says that they're not challenging on that basis, we will not need to present that evidence, but I wanted to make sure they were aware. Finally, Your Honor, I put on the record the issue of how we're gonna handle Jarecki, Smerling, and Zach Stewart Pontier, Z-A-K-P-O-N-T-I-E-R, and Stewart is S-T-U-A-R-T, I took it out of order. How we're gonna handle them, given the issues regarding the shield, et cetera, and I would just ask the defense to make sure that in their cross-examination, that they understand that they cannot ask any question about any unedited footage, any unedited, not unedited, any unshown footage, unaired footage, any unpublished documents, any question about sources. I don't want there, my suspicion is there's going to be a slip up, not necessarily because they're trying to do something sneaky, but because of an ignorance regarding what the law is. So all I can do is point it out, Your Honor, and make sure that they don't do it.
Well, I think that's resolved. Also, we've, I think, made pretty clear that the shield applies to such evidence. So intentional violation of that would not be well taken. So, with that, shall we adjourn until the 10th?
Thank you very
December
much.
10th, Mr. Durst, I'll have you back, ordered back here for December 10th.
Are we adjourning, or are we?
You know, I thought we were still gonna do,
I think we can't. So we'll move through it quickly on the 10th,
okay.
as quickly as we could have today.
Thank you, Your Honor.
We'll have the whole day.
Your Honor, Mr. Bailing is asking, is the court's plan still to be dark on Fridays during the trial?
Yes.
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 Okay.
Department 81 is adjourned.
Good evening, everyone. Keep talking here, keep trying to add more.